is now in session.
And good morning, council, and appreciate you participating in this oral argument by Zoom. This is I don't know if it's a new experience for either one of you, but we're still getting used to the idea. So bear with us as we progress. Before we get started, I want to take a few moments and run over the ground rules. First of all, I want to introduce our panel for this morning. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis. I'm Steve Stafford from Dyersburg. Both of you are experienced practitioners, been to the Court of Appeals before, just probably not by Zoom. And we're going to follow the same format as we always do. If you're the appellant, well, each side, first of all, gets 15 minutes for its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your oral argument. Otherwise, we're going to follow the same formalities that we always do. I want to thank Mr. Hibner for being the mastermind of all this and working diligently to prepare the court and the litigants for participating in this. And I want to thank also the AOC staff. They're the technology whizzes behind all this. So without wasting any more time, Mr. Hibner, if you would call the case, please.
Richard Allen Ellis versus Donica Ann Woods Ellis.
All right, we'll hear from the appellant.
Good morning, Your Honors. And as you said, it's a new experience to do this by Zoom. Judge Stafford, Judge Golden, Judge Armstrong, it's good to be here. I would like to request 5 minutes of rebuttal time.
All right, sir. You may proceed.
As you know, my name is Daryl Blanton. I am from the Memphis Bar, and I represent the appellant Allen Ellis in the current case in front of you. Judge Golden and Judge Armstrong had this case on its first appeal, as this is the second time it's been before this court. The issues that we have are pretty much the same. They deal with alimony and attorney's fees. I'm going to touch briefly on the alimony and attorney's fees as we go through not only some of the issues of fact, but the issues that we have in this second appeal. The first appeal dealt with the question of whether or not the trial court erred by not reducing the amount of alimony by the amount of money Ms. Ellis could earn on a reasonable basis. This court vacated the alimony award and remanded it back to Judge Russell with instructions to determine the amount of money Ms. Ellis could earn based upon the proof that was presented. And that's basically the crux of my argument, the proof that was presented. At the trial, both parties submitted expert witnesses to the court. Dr. Ellis submitted an expert, and he opined that Ms. Ellis could work and earn, and I'm going to use some round numbers, between $3,000 and $4,000 a month. Ms. Ellis presented her own expert. That expert presented that Ms. Ellis could earn about $2,500 a month to $3,500 a month. The expert that I'm going to really hone in on is the expert that was presented by Ms. Ellis, because it's important to note that Judge Russell, in his second ruling, submitted that it was not feasible nor practical for Ms. Ellis to return to work, and therefore determined on his own that her employment and her earning capacity was basically zero, disregarding the fact that this court sent it back to him saying, please review this in light of the fact that, number one, the statute provides that the first factor in determining alimony is the relative earning capacity. And number two, the fact that two experts opined that Ms. Ellis had an earning capacity. And so in my brief, I spend some time I think it's on page 8 of my brief, but I talk about the questions that the expert for Ms. Ellis was asked, because those questions are directly related to the finding by Judge Russell in his second finding that her employment would be not feasible or impractical. If the court please, in volume 6, I think it starts on page 302 and following, are the actual questions and answers that when Ms. Bartholomew asked the expert, did you take into account the fact that she was 60 years old or soon to be 60? His answer is yes, I did. But yet Judge Russell says, because she's 60, she can't work, even though her expert said she could. And so this court, when you vacated the alimony award and you remanded it, you said you need to look at this as if in the light of the proof that was presented. I'm trying to find my pages, but y'all have read it and you know what it said. Judge Golden, you wrote it and said, we want you to look at this alimony based upon the proof that was presented. And under the Duncan case and under the statute, you must, that's the word that was used, must take into account the reasonable earnings that you can attribute to the recipient. And instead of doing that, what the judge simply said was, well, I find that it's impractical and it's not feasible for her to return to work, even though her expert said otherwise. So I likened the alimony award in this case to a division of property award because I couldn't find any case that says, as it relates to the amount of alimony or in determining the facts to award alimony, the parties are bound by the proof they present. And in this case, there is no proof by anybody that it's not feasible for her to work. All of the proof is, including by her expert, that she is able to work. In fact, the first finding by Judge Russell was she's able to work and earn a living. And so that's why y'all sent it back. The second issue that is raised on this appeal is, again, the attorney's fees. Attorney's fees are awarded as alimony and solito. That's not a question. But the question then becomes, how do you gauge that in light of the facts of this case? And in this case, before you take into account the debt of the attorney's, Ms. Ellis's attorney's fees, the division of assets was approximately 70-30. And so then when the court awards or orders Dr. Ellis to pay the fees, it becomes even less, like 90-10 on a division of assets. And what Ms. Ellis wants you to do is to put these attorney's fees in a vacuum and say, well, because he can afford to pay them in the future, then he should be ordered to pay them. But as was pointed out in the Gosnewski case, there are two ways that you determine whether or not attorney's fees should be awarded. And it's in the disjunctive, which means it's either one, it's got to be both. If Ms. Ellis has the resources, the actual resources to pay her fees, then it's not appropriate to award the fees to Dr. Ellis. If Ms. Ellis can pay her attorney's fees with her income, then it's not appropriate. And so if you look at the fact that Ms. Ellis in her division of assets got, and I'm again use round numbers, $950,000 to Dr. Ellis's $350,000, then you cannot say that by paying $120,000 in fees that Ms. Ellis has depleted her assets. What Judge Russell has done is taken the statute and the case law and applied it only to Ms. Ellis. Because if the question is, by the award of an attorney's fees, will this deplete a person's estate? The answer, as it relates to Dr. Ellis, is yes. If his estate is $350,000 and you order him to pay $120,000 in attorney's fees, Ms. Ellis's estate remains at $950,000, while Dr. Ellis's estate reduces to about $220,000. That's an inequitable division of assets. So let's liken it to a Discover Card bill. Let's presume, for purposes of discussion, that Ms. Ellis had put her attorney's fees on a Discover Card, and she ran up a $100,000 Discover Card bill, all for attorney's fees. When the court then looked at the net estate, it wouldn't take that Discover Card and just act like it doesn't exist. It has to take it into consideration as a totality of the division of assets and liabilities. It didn't do that in this case. It simply said, I'm going to award $950,000 in assets to Ms. Ellis. I'm going to award $350,000 to Dr. Ellis. And then I'm going to make him pay $121,000 in attorney's fees. And so my position is that in and of itself makes the award of attorney's fees inequitable, and the court should not have granted it. And I'll refer back to my brief unless y'all have any questions.
Seeing none, we'll hear from the appellee.
Thank you.
Am I unmuted?
You're fine.
All right, great. Good morning. My name is Julie Bartholomew. I represent the appellee wife, Ms. Donica Ellis. As this court knows, this is about a remand and a review a second time of the same issues we had addressed at the previous appeal. The first issue being the alimony and futuro award. The case was remanded for two reasons. The instructions were that Judge Russell was ordered to both consider the type of alimony and the amount of alimony. Specific instructions were given about how he was to do that and what he was to consider. I cited in my brief the Tennessee law that says that the law of remand requires the trial judge, his sole responsibility is to strictly follow the instructions. And I submit that when you compare the court's opinion and the instructions that were given in it, and you compare that with the memorandum opinion that Judge Russell issued, you will see that he meticulously followed those instructions. Now, the theory of the husband is that those instructions somehow dictated a particular result, that it dictated that the court had to take certain numbers that were testified about as far as wages that could be earned from nursing, and he had to reduce the alimony, that it was mandated and dictated by those instructions. And I submit that that is not the case. There was never an instruction of a particular result that had to be that had to come out of the remand. In fact, those instructions were very much an open-ended instruction. This court does have the power to instruct a court to make a particular ruling, a particular finding, make a particular result, but it did not do so in this case. In addressing the alimony, the husband has not challenged the type of alimony, so I suspect we need not go there. The court awarded alimony in futuro as it did on the first time. The court explained, as it was required to do by the instructions, why it made a statement that the wife had a need of $8,000, but then in the next sentence awarded her $9,000. And I believe the court was very specific in explaining why that occurred. He explained that the affidavit of the wife from which he drew the $8,000 need did not include her income tax liability, because he because the $8,000 did not include that income tax liability, an additional amount needed to be added to it to cover that expense. Ultimately, the court considered the new federal law that was enacted while this case was pending on appeal that permitted a trial court, when it's modifying an award of alimony in futuro, to apply that new law, which makes the alimony non-deductible to the payor spouse and is not included in the income of the recipient spouse. In order to accommodate the wife's actual need, which was found to be $8,000 exclusive of her income tax liability, the court elected to apply that new law at its discretion and decrease the award to $8,000 per month. The court also explained how it arrived at the $8,000 figure, and I think both of the briefs addressed the particulars of how he arrived at that figure, which he has to just.
Ms. Bartholomew, I was just looking at the opinion, and in the concluding sentence, or just prior to the concluding sentence, it says, "We further reiterate that the trial court must consider the evidence regarding the range of wife's reasonably anticipated income."
Yes, sir.
Are you suggesting that he did that?
Yes, sir. He considered the range, but in light of other proof of the wife's age, the amount of time that it would take for her to get training to even go back to work, he found that even though in the abstract she can earn certain monies from working as a nurse, in the practical world, being retirement age, it was not feasible for her to go back and restart a career in nursing that had been abandoned 30 years before that.
Let me ask you, that finding on remand, is that consistent with his finding in the original trial? Because in the original trial, he said that the wife, let me find it. He said that the wife could reasonably re-enter the employment market and is capable of earning a reasonable income as a nurse. That's what he said in the first case. And then when it went back to remand, there was no further hearing. So how could that finding change?
The finding didn't change, Your Honor. There's just a difference between being capable of going back to work and earning a living and it being feasible to do so based on other factors, such as one's age, the amount of time out of the job market, and other factors. That was not the only factor that the court was ordered to consider on remand and determining what would be an appropriate alimony award. That was one of many factors. So he didn't change his opinion that she was capable of working. She is physically capable of working. And he did hear testimony of what the earnings could be if she did re-enter the market. But the reason he didn't reduce it to begin with is because apparently he felt it was not feasible, although he did not articulate that in his original ruling. So he explained it further on remand that was his thinking, that while she was capable of doing so, it was not feasible for her to do so.
Did Dr. Strouser testify that it was not feasible for her to go back to work?
I don't think the question was asked, is it feasible for her to go back to work? I don't think that was part of the proof, Your Honor, from the witnesses, but it was certainly within the prerogative of the trial judge to make that conclusion after hearing the proof from the experts and also considering the other factors that go into a decision to re-enter a job market when you're a retirement age.
But let me make sure and clarify this. But your own vocational expert did not say that it was not feasible for her to go back to work. And he testified about the jobs that she could do, given the fact that she is a licensed nurse and also has a degree that allowed her to teach earlier in her marriage.
Sir, those go to findings that she has some capability. When she had a teaching license some 30-something years ago, yes, she has some training that is way outdated. She would have to get training to go back to teaching, as well as get training to go back to nursing. And there was no proof put on by the husband about that interim period or the cost of it. But the court found that it would be substantial and last at least a year. Now, Miss Ellis currently
I'm
is.
sorry, but he found that on remand, right? He found on remand it would take a year.
He made specific findings on remand when he further explained his rulings. Yes, sir.
And is that without any further proof at the remand that he made that finding?
There was the only proof that was submitted on remand were some affidavits from attorneys that I submitted on behalf of Miss Ellis. Although the judge allowed the parties to put on any proof they wanted to, no one put on any additional proof.
Let me be clear. The affidavits went to the attorney fee, not the alimony. Is that right?
That is correct.
So there was no further proof on remand that she couldn't work and that it would take her a year to be retrained.
The proof at the original trial was that it would take a year to be retrained. There was no proof saying she could not work because she could. She was physically capable of working, Your Honor, but the practicalities and feasibility of going back into a field that you had been out of for so long, and when you had to retrain for it, made it an impractical solution. I believe that was the understanding of the judge, both the first time and the second time.
Okay.
Okay. Given that the court made these specific findings that that Ms. Ellis had an $8,000 need, I believe the proof supported that. It was proof from the original trial, Your Honor, but the proof continued to be relied upon on remand. Now, the second issue has to do with the attorney's fees, and I'm just going to briefly speak on that. The only challenge that was raised on this appeal had to do with the fact that it was a claim that Ms. Ellis could afford to pay her own fees. I cited to the court the Diffie case. It's on page 35 of my brief, and I believe it's directly on point. In that case, and as well as this case, a long-term marriage, the wife was not employed, and the wife was awarded considerable assets as part of that divorce, but it mainly consisted of illiquid assets, a home, and that was the same situation here. While Ms. Ellis did receive substantial assets, they're not liquid assets that she can use to pay attorney's fees. And the suggestion that she should go out and sell her house and furniture in order to pay that is just ludicrous. The proof was replete with evidence that the husband has a generous income and has plenty of assets. And the way that Mr. Blanton has slanted the proof about the percentages of the division, I believe it's not accurate to say, because the court did not even put a percentage on those assets or a value on those assets. He just enforced what the parties agreed as far as the division. In final conclusion, Your Honor, I believe that we submitted a request that the attorney's fees for Ms. Ellis on this appeal be considered and awarded. She has incurred attorney's fees both at the trial level, on the first appeal, at remand, and now on this second appeal. And as I noted in the brief, she was denied an award of her discretionary costs. So it's been a very expensive proposition for her to defend the awards that were made in the original trial. And I would just ask the court to consider the equities of the case in consider making an award of those fees.
Let me ask you, is the attorney fee balance the 120, or is it the 120 minus about $30,000?
Miss Ellis did pay $30,000 towards those fees while the divorce was pending, and that was part of the proof at trial, Your Honor.
So the balance owed right now is not 120, is that right?
That's correct. It's in the $90,000 once she had paid the $30,000 down.
Okay.
All right. Thank you. We'll hear from the appellant in rebuttal. You're muted, Mr. Blanton.
I'm sorry, we're learning.
I understand. We are too.
So now I got to get you back on here. Okay. I want to start with the premise that the court determined that it's not feasible for Ms. Ellis to return to work because she needs training. And I want to specifically read the question. Now, this is in volume 6. It's on page 303 of the transcript. This is a question by Ms. Bartholomew. It says, did you make any findings concerning the job market for someone who had been out of the market for so long? Did that affect your opinion in any way? Answer. It did impact my opinion. Again, it impacted my opinion in that I reduced her capacity from being a floor nurse, which she would have the qualifications to do, to look more at an entry-level type office nurse or case manager, which would be more conducive to an individual re-entering the labor market, having been away from the labor market for an extended period of time. So he took into consideration the fact that she had been a floor nurse when she was a nurse before. What the expert for the wife continued to say was, she can still be a nurse, but unless she's going to get this training, I'm going to say she should be a nurse in like a doctor's office, not on the floor. So she doesn't need to get that retraining. She can go right in because she has a valid nurse's license, go right in and start earning in a doctor's office. In fact, husband's expert opined that she could do administrative work. She could go work in an office. She could answer phones and do those things. But I chose to deal with the expert that the wife presented because he limited everything that he did to her nursing ability. Nursing. The next question by Ms. Bartholomew said, did you take into account her age and how close she was to retirement? Answer, yes, because for her to return to being a floor nurse, she'd have to get some, retraining or skills updating. So some things that would put her out of the labor market for even a longer period of time. And, given that she's 60 years of age or approaching 61 now, looking at the typical retirement age of 65, getting additional training to be out of the labor market or take her out of the labor market would not necessarily be real conducive to maximize earnings. So he is saying, I didn't want her to get retrained. I wanted her to do the things that she was capable of doing so that she could enter the job market immediately. But yet, what the judge said was, alimony, this is from the memorandum opinion and order on remand, the alimony award should not be reduced as husband contends to account for speculative projections of potential earnings from nursing that are not realistically available to wife in view of wife's age. It would not be equitable, reasonable, or practical for wife to return to the workforce and attempt to train for and restart a nursing career that she gave up in 1987. And none of that is supported by the proof. I want to cite the brief or a page from the brief, if I can find it. I can't find it, so I'll have to do it later or do it by memory. Ms. Bartholomew, in her brief, said that a judge's discretion has to be based upon the proof that was presented. I wish I could find that real quick. I'm sorry I can't because I'm standing and that all of this is kind of crazy on us. But when you look at that and you determine that it's not supported by the evidence, his findings are not supported by any of the evidence, and therefore his discretion was abused in his determination in the amount of alimony. Now, the last thing I want to leave you with is this. Ms. Bartholomew said it once, she said it 3 or 4 times. Ms. Ellis is capable of working. And the first factor in determining alimony is the capacity to work. And those words are synonymous, I would submit to the court. Thank you very much.
All right, counsel, we appreciate your argument. We appreciate you participating with us by Zoom. We will do our best to get you an opinion at the earliest possible date. Again, thank Mr. Hibner and the AOC staff. Mr. Hibner, if you will conclude this case, and we will be in recess until the call of the docket for the next case.
This honorable court is now in recess until 1 p.m.
Thank you, counsel.
Thank you, Your Honors.